Hi, Misha Gill with Speedwell Law. So you've decided to do your estate plan. What now? All right, so the first thing that you're going to do is you're going to start pulling together your financial information. Most likely, that's what most people do. But there's a mistaken emphasis on that financial information. Yes, it's all important. Yes, I want to know exactly where you have all your bank accounts and all your brokerage accounts and all that stuff. But I'm also going to send you a form that's going to prompt you to collect all that information. And so you should just use the form that's provided to you by the estate planning attorney to compile all that information, because that's how the attorney is going to be used to seeing that information. The better thing that you can spend your time doing right now before you start the estate planning process is pulling together information about your properties, your real property. And so the document that we need is called the deed. Also sometimes called the deed of bargain and sale. There's also quitclaim deeds. But what we're really looking for is the deed to any property that you own. And so where do you find the deed? Well, most likely you're going to find it with your closing documents from when you bought the property. There's going to be another document in there called the deed of trust. It's a little confusing, I know. We don't want the deed of trust, we want the deed or deed of bargain and sale. The deed of trust is 8 to 9 pages long. The deed is 2 to 3 pages long. And so that's the document that is a reflection of your record ownership of the real property. The deed of trust is a debt instrument, so we're not as interested in it. If you can't find the deed, if you can't find your closing documents, there's another way to get the deed, and that is through land records or the county recorder's office. Basically what you're going to do is you're going to contact the courthouse for the jurisdiction, the circuit court for the jurisdiction where that property lies. So here in Alexandria, Virginia, the city of Alexandria has its own court system. Fairfax County, we have a part of Alexandria that lies in Fairfax County. There's also land records for Fairfax County. Okay, so you've pulled together your deeds, you're starting to look for attorneys so that you can get their intake form. How do you choose an attorney? And that is a difficult decision. And so here is my advice for how to select an attorney. The things you're going to look at are reviews, their website, and their location. You want them to be convenient, you want them to be well reviewed, you want them to care about their image to the public, which is their website. A word about reviews, take it with a grain of salt. It's great if someone has a lot of reviews, a lot of good reviews. That is important. That means they care about their business. If someone has a bad review, I would also counsel you to take that with a grain of salt. It's a great opportunity actually for you to speak to that attorney and find out the other side of that story when it comes to a bad review. And that interaction with the attorney about that bad review is going to tell you a lot about how that person is. Because obviously it was an adverse situation. There might be a very good reason why there was an adverse result for that attorney, or there might not be. Maybe it is just nonsense, and you're going to be able to glean some information from that interaction with the attorney. So reviews, take it with a grain of salt. It's very important, but it is not the full picture. And so what you really need to figure out when you're talking to an estate planning attorney is fit. And as an attorney, you can't be everyone's flavor of ice cream. Some people like vanilla and some people like Rocky Road. And that's fine, that's okay. Those are both great ice cream flavors, but not everyone likes them both. And so you need to figure out whether that estate planning attorney is the right fit for you. And the only way to do that is to talk to them. When you're talking to that attorney, other great things you can talk about are their process and how they charge. What I would counsel you to think about when it comes to process is that this is one of the reasons why you would go with an estate planning attorney versus a general practitioner, is that process is going to be really well defined. We think about estate planning in issues for clients on a daily basis, and we remove as many hurdles to completing the estate planning process as possible for clients. And that's because we want you to have a good experience, and we want to make sure that we get you to the end, which is a successful signing of the documents. And we have designed a process that's extremely oriented towards that goal. a general practitioner might not have as well defined a process. When it comes to charging, there are two fundamental ways that attorneys charge for their time. And make no mistake, the only thing that we sell is our time, so we are careful with it. There's flat fee representations and there are hourly representations. Many people are seeking a flat fee representation when they are engaging an estate attorney. And that's nice because it offers a couple of things. One, it offers certainty as to how much the representation is going to cost, and that is that there's peace of mind when it comes to that. Two, it removes a barrier to clients getting what they want. If you know that you've already paid for the time, that you've already taken care of the money problem, it's going to remove a hurdle to you reaching out to that attorney and asking the question that's really on your mind. And that's what we really want from our clients, is we want candor and we want trust. You have to have the trust in order to get the candor, and part of that is knowing that you've already paid a fair fee for that attorney's time. But that's not to say that hourly representations are unfair. Hourly representations can be great value for clients because it is just the fairest way to charge people for your time, is keeping track of it in tenths of an hour increments. Some attorneys will charge you in quarter-hour increments because it's less of an administrative burden. And that's fine, but we do tenths of an hour. And so why would you prefer an hourly representation? Well, you might be a client who has a really straightforward situation. Everyone thinks their situation is simple and they just want a simple will. But if you really have a well thought out idea of what you want to do, and you're going to take the attorney's guidance very seriously, then you might have a really straightforward representation where you can get a better value out of that attorney by doing an hourly representation. An hourly representation might be necessary in certain circumstances where the scope of work is unknown or is likely to be elongated or shortened depending on certain outcomes. And so hourly makes more sense for those types of representations as well. But get a general idea from the attorney how long they think it's going to take. So that's my advice for fees. So once you've talked to the attorney, you've read the reviews, looked at the website, figured out that they're convenient, you're going to assess and make a decision. And that's the what now. Ultimately, it comes down to hire an attorney. Okay, so to summarize, you've decided to do your estate planning. What now? Pull together your deeds and record ownership of any real property that you have. Get the intake form from the estate planning attorney that you're going to work with. Oh yeah, select that attorney. Okay, so thank you for watching my video. This is Misha Gill with Speedwell Law, and we hope to be working with you soon.